Welcome to the League of Women Voters Presents the Constitution. We are happy to have our guest speaker, Representative Elaine Nekritz.
Hi, my name is Elaine Nekritz. I'm a former member of the Illinois House of Representatives and also a very proud member of the League of Women Voters for many years, even before I became a member of the Illinois House. So the U.S. Constitution establishes the rights and responsibilities of the government vis-a-vis the citizens of this country and also relative to the states. And both of those are critically important components of the Constitution. The Constitution also sets up the national government, and it does that by establishing three separate branches of government. One branch would be the executive branch, which is the president and all of the agencies that are within the executive branch. The second would be Congress, which would be the House and the Senate. And then the third would be the judiciary, the U.S. Supreme Court, and then the various levels of courts that are under that. The president has specific obligations and rights under the Constitution. Those would include the ability to control all the executive branch and to establish a cabinet that would consist of a number of members, including the Secretary of State, the head of the Department of Energy, of Education, and a variety of those kinds of things. So all of those agencies are controlled by the executive branch, and that gives the president quite a bit of power over how laws are implemented and how the citizens interact with the government. The legislative branch consists again of the House and the Senate. The House has 435 members, and they are elected proportionally from the various states. So there is a census every 10 years that determines what the population of each state is, and that then determines how those 435 members of Congress are allocated among the states. The Senate has 100 members, and there are 2 members elected from each of the 50 states, and they are elected at large from each of the 50 states. So altogether, it constitutes 535 members of Congress. The legislative branch has authority to make laws, and that's how laws are made and then signed by the president. And they have to be passed by a majority of the members of Congress in order for them to become law. The House, the federal House, has primary authority over the budget, which is obviously one of the most significant things that the legislative branch does, is to spend all of the tax dollars. So they have the ability to raise tax dollars and to spend those tax dollars. And that really all starts within the House through the House Ways and Means Committee. Once the legislature, the Congress and the Senate pass something, the president does have the ability to weigh in on that. He can either veto something or he can sign a piece of legislation, and if he vetoes it, the Congress can override it, but it takes a supermajority of votes in order to be able to override that. So that usually results in a negotiation going on between the executive branch and the legislative branch about a particular law and what it's going to say and what its effect will be. The judiciary has 9 members of the Supreme Court. Those are appointed by the president with the advice and consent of the Senate. So generally they have to work together to make sure that they agree on who will be appointed to the U.S. Supreme Court. As the Supreme Court has developed over the years, it really is the final decision maker as to whether or not a law can go into effect and whether that law complies with the U.S. Constitution. And so the judiciary, the Supreme Court has quite a bit of authority over the making of laws in this country and what kind of effect those laws will have. There are also appellate courts, courts of appeal that are divided up around the country among the states, and district courts, which are generally are fairly state-specific, But again, all those judges are appointed by the president with the advice and consent of the Senate.
Okay.
The U.S. Constitution establishes the relationship between the federal government and the various state governments. The states are also sovereign entities that have that they're established separately, but the relationship between them is established by the U.S. Constitution. And so there are rights and responsibilities that are reserved to the federal government, and everything else is reserved to the states. So the states have a lot of authority over what goes on in their area and with their residents. And there's a lot of tension also between the federal government and the state governments as to what constitutes federal authority and what constitutes state authority. But again, the Constitution says very clearly that the federal government has limited rights and responsibilities, and everything else is left to the states. The U.S. Constitution was amended not too long after it was instituted to add the 10 amendments, the first of which is freedom of speech, freedom of religion, freedom of association, and so forth. And those are probably among the most important aspects of the Constitution and how it defines the relationship between the government and the citizens. So again, the First Amendment includes freedom of speech, which gives us, and the freedom of the press, which gives citizens and the media the ability to cover government freely and openly, and to have access to the records of government, and to investigate into the operations of government to make sure that everything is operating according to the Constitution, and that the citizens are aware of what their government is doing. The First Amendment also indicates that the federal government shall not establish any religion, and typically we say that that's the freedom of religion in this country, but it really is that the government shall establish no religion, and that has, again, been an important a platform for the citizens that that we can practice religion freely without having anything imposed upon us by the government. The freedom of association is also in the First Amendment, which again allows citizens to gather, to protest, to collectively bargain. So the freedom of association is a basis of a lot of our freedoms in this country. The Second Amendment in the Bill of Rights has to do with the ability to own a firearm, and that has been something that has been the subject of a lot of controversy and a lot of legislation in this country. But it is something that again, for a lot of folks, gives them the sense of security and safety, and also allows them to feel that they are protected if the government should try to intrude on their rights. Another one of the important amendments in the Bill of Rights is the Fourth Amendment, and this is, at its core, what it talks about is unreasonable search and seizure by the government. This is the amendment that affects our criminal justice system and provides what powers the police have, what powers the courts have, and what powers prosecutors have in order to detain someone and to take away their liberty, to take away their property. And so the Fourth Amendment is again a really one that we should be highlighting, and have folks understand that government has limited powers to take away your freedom and to take away your property, and there are very tight controls over how they can do that. So the Fifth Amendment also has to do with the ability of government to take away someone's freedom, and its important provision would indicate that citizens cannot be tried twice for the same crime and on the same facts, that's the double jeopardy provision of the Fifth Amendment that would be the important part of that one. The Sixth Amendment also deals with the criminal justice system and provides that citizens shall be entitled to a trial by jury, and it is up to someone being charged with a crime to select whether or not they want to have a jury hear their case. But in any event, citizens are always entitled to ask for that, and so that a jury of their peers can make a decision after hearing the facts as to whether or not someone is convicted and whether or not their freedom can be taken away. The Eighth Amendment in the Bill of Rights defines what kind of penalties can be imposed if someone is convicted of a crime, and it requires that it not be cruel or unusual punishment. And the subject of the death penalty has been the subject of a lot of scrutiny under the cruel and unusual punishment provision. It also sets what the parameters under which a person can be detained before they've been convicted of a crime, and that there won't be an excessive monetary or bail requirement in order to keep them in jail. At the time that after the Civil War, when the anti-slavery provision was adopted into the Constitution was also amended to assure that citizens had the right to vote regardless of their color or national origin. And it also adopted another amendment that assured that citizens would have due process of law and equal protection under the law, again, despite their race. When the United States was first formed, the federal government did not have the ability to tax citizens in the way that we know it today. They collected a variety of smaller taxes, but the income tax was not authorized under the U.S. Constitution, so the federal government could not collect such a thing. So the Constitution was amended by the 16th Amendment to allow for an income tax that could be collected from all of the citizens all over the country. Until 1920, women did not have the right to vote under the U.S. Constitution. And it was a very controversial amendment, but the states finally ratified that in 1920 for the first time, giving women the right to vote and to run for public office. The right to vote in this country has not always been guaranteed, even though you might otherwise qualify. So the Constitution includes a provision to protect against folks having to pay or pay a poll tax in order to be able to exercise their lawful right to vote. The Constitution makes it very clear that that's not a legal thing for either the federal government or the states to do. There are several age limits that are set in the U.S. Constitution. First is the right to vote. You have to be at least 18 in order to vote in a general election. To serve as president, you must be at least 35. To serve as senator, at least 30, and as a member of Congress, 25. The president serves 4-year terms, and by Constitution, they are limited to 2 terms. That was not the case until the 1930s, I would say. If something happens to the president and the president is impeached or is unable to perform his duties, the vice president will be sworn in and recognized as the president. If something happens to the vice president, the third person in line to perform those duties is the Speaker of the House as a member of the U.S. Congress. Members of Congress are elected for 2-year terms. There is no limit on the number of terms that they can serve. And members of the Senate are directly elected by the voters in each particular state, again, 2 per state, and they serve 6-year terms. They also have no limit on the number of terms that they can serve. The Founding Fathers were pretty clear in the Constitution that they wanted a separation of powers as a check and balance on the executive branch, the legislative branch, and the judicial branch. And so they assigned the ability to make laws to the legislature, to approve laws and implement those laws to the executive, and oversight to the judiciary to make sure that the intent of Congress was being complied with by the executive and that those laws did not violate the parameters of the Constitution. Those checks and balances are a very important and almost unique feature of American-style democracy. And the checks and balances that were built in are also a very important part of the government's function and its ability to make sure that no one branch of government, no individual president, no Congress takes on more authority than it is allowed to under the Constitution.